One of the most common questions I get is about their assets. What assets are at risk? Am I going to lose my home? Am I going to lose my car? It's a very common question, and there's a lot of myths surrounding what you may or may not lose in bankruptcy. Let's talk about how Chapter 7 works in the context of your assets. Most of the time, our clients are most concerned with real estate. Real estate is their primary concern, it's their homestead, and it's the first thing that clients routinely ask about. And it's our obligation and our duty to make sure that the client understands what happens to their real estate in the context of a Chapter 7. When it comes to real estate, whether it's your primary home or a secondary home, is decide whether you have too much equity in your home to file Chapter 7. Most of the time, you're going to secure a CMA, which is a market analysis that will help us determine how much equity you have in your home. Under no circumstances do you want to file a Chapter 7 if you are above the threshold with respect to equity in your home. I can think of the hunters who came in to see us and they wanted to keep their home and file a Chapter 7. They otherwise qualified. They checked the other boxes, as we said. They didn't own a business. They didn't have too much equity in other personal property. They didn't have too much money in the bank, but they had a home. So we had to make sure, much like a doctor runs blood tests to see whether and if someone qualifies for a certain kind of procedure, this is the part of the process where we secure a comparative market analysis or a CMA, and we make sure that there's not too much equity in the home. Assuming that there's not too much equity in the home, and we do that through something called a liquidation analysis, we want to make sure that the home is going to be protected. Then, and only then, do we decide to file Chapter 7 to make sure that the home is protected and the equity is what we call exempt or protected. As it relates to the hunters, our clients, after we secured the CMA, we completed our liquidation analysis, we reviewed mortgage payoffs and comparables in that neighborhood, it was determined there was not too much equity in their house and they were able to file a Chapter 7. They were very nervous. We went ahead, we filed, and as I suspected, and we've done in many other cases, the trustee decided that that house was not an asset of the bankruptcy, and he did what's called an abandonment, which basically filed something with the court that says there's not enough equity for the court to be concerned about the asset. The hunters were pleased, they received their discharge, they stayed in their home, and they continued to pay their mortgage as they ordinarily did before they came to see the firm. In a Chapter 13, there are really two driving factors that decide how much has to be paid back. One, the amount of equity you have in your home, and two, the income. And sometimes both of these criteria are used in a formula to determine how much you have to pay back. I like to say that Chapter 13 is a very different kind of bankruptcy than Chapter 7. In a Chapter 7, if you file a bankruptcy and you have too much equity, the home is at risk. In a 13, it's a little bit different. Clients can have more equity in their home, but the more equity that they have, the more they have to pay back towards creditors, which translates into a higher trustee payment. The client will always be aware of what that payment is because it will be, most of the time, feasible with their budget, and the client will be aware of that payment before they file. I'd like to think of some clients that came in to see us recently, the Kellys. And the Kellys had a specific view of how their case was going to go. They thought they had to pay back all their debt, and they thought that once we told them that Chapter 7 was not feasible for them and they didn't qualify, that meant that they had to pay back all their debt. Once we analyzed the Kelly situation and we finalized their trustee payment was 50% lower than the payments that they were making before they came to see the firm and my team. They were delighted. So their trustee payment landed somewhere around $1,000 a month as opposed to the $2,000 that they were making before they came to the firm. I love a situation like that because it's an immediate savings for the client. The client's stress level has immediately been reduced, and we've made a material impact on their budget almost immediately, reducing the stress in the family unit. Filing bankruptcy can be a daunting prospect, as we said, but it's essential for you to use the consultation as a tool to gain control and understand what your options are so that you can improve your financial future if it's right for you. Look, if you're facing financial distress, you're late on your car payment, you're late on your mortgage, or somehow you've fallen behind on other obligations and you need a financial fresh start, there's help available for these situations so that you can understand what your options are. If you find yourself facing financial difficulties, contact our firm. Our consultations are complimentary and confidential, and you will leave the consultation after talking to our team understanding what your options are. I don't know if filing bankruptcy is for you, and speaking to a bankruptcy lawyer does not mean you're filing bankruptcy. You're just getting to understand what your options are. Making the consultation appointment is nothing to be embarrassed about and won't cost you anything. I'm attorney Lee Perlman, NewJerseyBankruptcy.com. I've been helping consumers and businesses secure their financial fresh start since 1994.